Welcome to the webinar. Today we're going to cover the Rape Survivor Child Custody Act here in Iowa. Our presentation is titled Rape Survivor Child Custody Act, What a Survivor Needs to Know. My name is Sherelle Thurston Shell. I'm staff attorney here at the Iowa Coalition Against Sexual Assault, and I have the privilege to be able to kind of guide you through this newer legislation as it is here in Iowa. So just a little bit of background information. The Rape Survivor Child Custody Act actually stems from federal legislation. It came from, in May 2015, Congress enacted the Justice for Victims of Trafficking Act. And Title IV of that act was actually the Rape Survivor Child Custody Act. And essentially what the act did was it directed the U.S. Attorney General to be able to make monetary grants to states that would develop or adopt qualifying legislation. And so we'll talk a little bit about what the qualifying laws, the stipulations for that was. But the U.S. Attorney General was able to provide states with an increase in stopped formula grant funding if they would be able to enact legislation that provided the opportunity for a mother to be able to terminate the parental rights of her rapist. Additional requirements for a state to have a qualifying law and qualify for the increase in stop formula grant funding is that not only would the mother have to be able to petition the court to terminate parental rights of her rapist, but also there couldn't be a requirement that a conviction be necessary. And then lastly, the court must utilize a clear and convincing standard. So this sounds like a lot of intense information at first, but just know that that was the requirements for the qualifying laws to receive this increase in funding. And we're going to go through each component so you can further understand the Rape Survivor Child Custody Act and burdens of proof and etc. So just generally, we know that sexual violence is underreported, certainly, and certainly under prosecuted crime in this country. We estimate that we have less than 5% of rapes resulting in criminal conviction. That's one of the reasons why you'll see the condition of mothers being able to terminate parental rights and not having a conviction required, because we know the nature of sexual violence and that it's very difficult to have a conviction in the criminal justice system, and also survivors may not want to seek or pursue the criminal justice system as a means or remedy for them. So Iowa Code, they actually have passed a Rape Survivor Child Custody Act that would adhere with the Attorney General's requirements to have a qualifying law to receive an increase in stop grant formula funding. So we have the provisions now in Iowa Code so that a parent, and I particularly choose those words, in Iowa here we chose to utilize non-gender specific language. So rather than it being the mother has the ability to terminate the parental rights of a rapist, the Iowa Code states a parent who was raped when the child was conceived can voluntarily terminate the rights of the parent who committed the rape. So it's much more gender neutral. Among adult women, an estimated 32,101 pregnancies result from rape each year. This statistic is coming from the American Journal of Obstetrics and Gynecology. We know that a substantial number of women choose to raise their child, the child that is conceived through rape. And as a result, they may face custody battles with the rapist. According to one study, 32.3% of women who were raped and became pregnant as a result of the rape kept the child and chose to parent. So if we think about the scenario, what are we asking of survivors? It's asking quite a bit to say, okay, you've had this horrible crime happen to you. It's resulted in a child, and now you have to continue to parent or co-parent with your rapist. We know sexual violence is about power control, and that's certainly a mechanism in which the rapist can continue to further victimize the survivor and make their ability to recover certainly more difficult. We see traumatic psychological effects for the survivor and making it almost impossible for her to recover. And certainly it has a negative impact on her ability to raise a healthy child. So given those facts, that's why the federal legislation was passed. Before the federal legislation was passed, only 6 states had statutes allowing rape survivors to petition courts to terminate parental rights. And so that's not enough, of course. And they sought to incentivize further legislation to be passed in states. And to date, approximately 45 states plus the District of Columbia have passed legislation conforming or qualifying with the Rape Survivor Child Custody Act. So that's good news. So just basically getting started, we remember our roots of advocacy. If you're dealing with a survivor that has been raped and a child has resulted, reaffirm to the survivor what happened was not their fault, and they are certainly not alone. As we see the statistics, this unfortunately happens too often. We want to reaffirm that they can decide how and when they talk about their assault. This can be very difficult, particularly when you're seeking some intervention from the court to terminate parental rights. The court's going to ask a lot of questions about the circumstance around the conception of the child and for further evidence of basically it being non-consensual and being a product of rape. So supporting survivors as much as you can through that, and then always reminding survivors that there's free and confidential support available throughout the state. So the Rape Survivor Child Custody Act in Iowa, like I said, the federal legislation permitted the Attorney General to increase stop formula grants. Iowa passed subsequent legislation that qualified, and as a result, they received an additional $26,913 as a result of passing this legislation that met the federal standards of the Rape Survivor Child Custody Act. Here's the act itself. You'll see the act shows that it was added to 2 code sections within the Iowa Code, section 232.116 and also section 600A.8. Identical language, though, stating that the court finds there is clear and convincing evidence that the child was conceived as a result of sexual abuse as defined in section 709.1, and the biological parent whom the sexual abuse was perpetrated requests termination of the parental rights of the biological parent who perpetrated the abuse. So when I'm discussing that we see the act itself, and it was added to 2 code sections of Iowa Code. The first code section, 232.116, actually is in the Human Services section of the Iowa Code. And this is a section utilized by DHS, county attorneys. It's when you hear about child in need of assistance or China cases, this is the portion of the Iowa Code that's being invoked there. The other portion in which the Rape Survivor Child Custody Act language was added is the 600A section, which controls voluntary termination of parental rights. And what that means is, whereas 232.116 is the involuntary termination section, the DHS or county attorney's office, the mechanisms that start when a child is in need of assistance, or neglect circumstances or abuse. That's essentially not a voluntary action by that parent. That's the state intervening. So that's the involuntary termination section. But for our purposes of helping a survivor go through the court system and voluntarily terminate the parental rights of their rapist, we're going to primarily focus on the 600A section that controls voluntary termination. So let's take a look at the code, and I read it earlier. We're going to kind of digest it a little bit more. So this is the Iowa Code section 600A.8. Again, it's the voluntary termination of parental rights section. So when we say voluntary, it's providing the option rather than DHS or the state mechanism kind of going because there's neglect or abuse circumstances alleged or that kind of thing. This is literally your survivor can go to the court and petition the court and say, I would like to voluntarily terminate my rapist's parental rights. And here's the grounds that I'm pursuing. And so that's where they would invoke the grounds in the section added by the Rape Survivor Child Custody Act. And so what they would allege to the court is that their child was conceived as a result of sexual abuse as defined in 709.1. We're going to take a look at that section here in a second. And they are basically requesting the termination of the parental rights of that parent. And they're alleging that they can provide clear and convincing evidence to support the fact or the court's finding that this child was conceived as a result of that sex abuse. So here's the 709.1 section, sexual abuse defined. Any sex act between persons is sexual abuse by either of the persons when the act is performed with the other person in any of the following circumstances. So the act is done by force or against the will of another. If the consent or acquiescence of the other is procured by threats of violence towards any person, or the act is done while the other is under the influence of drugs or induced sleep, or otherwise in an unconscious state, the act is done against the will of the other. So essentially done by force, done by threat, force, or some kind of drug-induced unconsciousness or state of sleep, then there's not consent there. Another section, or another subsection which is covered is that the person in which the act is being done upon is suffering from a mental defect or incapacity, which precludes them from giving consent. So if they can't consent, then it's sex abuse as defined by 709.1. If you lack the mental capacity to say no, then they are committing sexual abuse as defined by this code. And then, of course, third provision is if the sex act is performed against a child. So we keep talking about this concept of termination of parental rights. What does that actually mean? So termination of parental rights means that the party, once their rights are terminated, they have no legal claim to the child in the eyes of the law. Okay? No legal rights, what does that mean? You can't have a say in where the child lives, or make determinations about his or her upbringing, education, etc. The parents whose rights are terminated becomes basically a legal stranger to the child. They can't have contact with the child without a legal guardian's consent. Who can terminate parental rights? Only a judge can terminate parental rights. So that's why we essentially, this process is set up so that our survivors can petition the court, we have to ask the court, can you, here's the circumstances, can you please terminate the parental rights of my rapist? The judge is the only party that can make a termination determination. And again, kind of going back to talking about the different code sections, the 2 code sections in which the Rape Survivor Child Custody Act language was added. The first section that is covering involuntary termination, a county attorney can ask for the parental rights to be terminated in a child in need of assistance case, or can invoke these same grounds in the Rape Survivor Child Custody Act. And then additionally, and that's what we're more focused on today, is the actual parent or survivor or guardian can ask that a parent's rights be terminated under the 600A.8 section. So I'm sure this is a term that many of you have heard, burden of proof. I think at least once in a lifetime, everybody's seen an episode of Law and Order. But we talk about burdens of proof in a variety of different ways. In criminal cases, we commonly hear beyond a reasonable doubt. In civil cases, you'll hear a lower standard that is called preponderance of the evidence. And in the language that we've been using for the Rape Survivor Child Custody Act and the requirement by the federal legislation stating, this is the burden of proof that has to be utilized. The burden of proof is clear and convincing. So we're going to unpack this a little bit. If we're thinking about burdens of proof in like order and rank and file, the criminal standard of beyond a reasonable doubt is the most extreme and severe and the highest to prove. If you think about that circumstance, essentially what a defense attorney has to do is just put doubt or show doubt in the state's case to the judge or jury, and then you can actually have a person be found not guilty. So that's a much higher standard if you think about that. It's more like you could visualize more of a 99% sure or 99.9% sure that this is what's happened, and this is essentially what occurred. In the very bottom, so we'll go to the opposite end of the spectrum, from the extreme to the least extreme burden of proof, we see preponderance of the evidence. And thinking about this visually or in terms of percentages, we frequently say 50% and a feather, or 50% and just a slight little extra would fit that burden of proof. And that's for preponderance of the evidence. So where does the clear and convincing burden of proof that we've discussed fall? It falls essentially in the middle. I would argue actually a little bit more towards the beyond a reasonable doubt, maybe more kind of like a 75% range. In working on this project, the office staff here, including the law clerks, tried to find the most simplified language to be able to explain clear and convincing. And unfortunately, it's compounded by lawyer legalese. So traditionally it's defined as you're showing that it's substantially more likely than not that something occurred, like you're telling the judge. But if you take a look at the language and you say, okay, clear and convincing, essentially what I'm saying is I want to be able to provide enough evidence so that the judge in this circumstance is clearly convinced that my child was the product of, or not the product, but was conceived by rape, and therefore my rapist's parental rights need to be terminated. So In kind of fleshing that out, I think the easiest way to describe it is the burden of proof is to clearly convince someone. And that can be all kinds of standards, and we won't engage in kind of discussion around percentages. Just at what point do you feel like you've provided enough evidence that someone can say, yep, that's crystal clear to me, that I'm convinced that that's the way it happened. So skipped ahead of here, but our discussion about clear and convincing evidence, we've engaged in that. So clear and convincing evidence, presenting evidence to the court. In order to meet clear and convincing burden of proof, survivor must prove that it is substantially, again, legalese here, but substantially more likely than not that their child was conceived by rape. Therefore, in order to protect the survivor and the child, and for it to be in the child's best interest to terminate the parental rights of the rapist. So we think about what can be considered as evidence. What kind of evidence can you help identify for the survivor, or help the survivor identify that they can show to the judge to clearly convince the judge, yes, this is how my child was conceived, and therefore my rapist's parental rights need to be terminated. There can be a variety of things, but a report to law enforcement can help. Documentation of that, whether or not charges are filed. The documentation or investigation report can be evidence. Receiving advocacy from services or victim service programs, showing that you had a starting point in which you were dealing with some trauma and had to seek sexual assault services. That can be additional evidence provided to the court to help support your assertion. Undergoing a sexual assault forensic exam. So if you were assaulted and underwent an exam, providing those records and dates and times, etc., can help be evidence to support, again, to clearly convince the judge that circumstances happened as you stated. And then seeking follow-up healthcare services and reporting to a healthcare provider. These are just a few things. There certainly, if you have any witnesses or witnesses that can testify to the impact or the trauma impact that you've had and the impact on your life, that would be some other options. But there's certainly innumerable possibilities. So what about the impact on child support and public benefits? Frequently, before the Rape Survivor Child Custody Act was passed here in Iowa or federally, this was a very common fear for survivors is, I need some public assistance. I need some assistance with supporting my child. And so therefore, they'll seek public assistance and receive something from child support services that says, I need you to name the father of the child. And essentially what child support recovery services is doing there is trying to recoup whatever monetary contribution the state is making by seeking it from the other parent or party. That should be, obviously it's never cut and dry in any circumstances like that, but it's certainly much easier and much simpler if there's not sexual violence involved, and essentially it's maybe just an absent parent or somebody that has not been court ordered at this point to provide assistance or child support. But for rape survivors, this can be absolutely terrifying. They just need some assistance with support, but it seems like it opens up this can of worms for them in which then there's going to be a paternity test or determination, and then this party that has harmed them is either made aware of the child or kind of reminded of the child, and can use it as a means to kind of manipulate and torment them further. So this is a very real fear. The Rape Survivor Child Custody Act, the point of that is it's basically trying to alleviate some of that, so that they can know that termination of parental rights, again, we said making the legal stranger of the child. You have no further say so. But it should not cut off then public benefits for that parent to help support that child. The federal legislation was incredibly silent on whether or not the Rape Survivor Child Custody Act and subsequent termination of parental rights would impact child support. It basically just left it up to the states. And so when you look at the provisions and the code sections added by Iowa, it of course provides for the opportunity for a parent to terminate the parental rights of the parent that committed sex abuse against them that resulted to a child, but it does not provide specific provisions to say, okay, once those parental rights are terminated, they still have to provide child support for this child. That's not the case. And actually, the way Iowa law is set up and its provisions, once parental rights are terminated, then the child support obligation is terminated as well. So that's certainly a discussion that you want to have with your survivor if they feel as if they would need the child support additional assistance, child support assistance, and would be seeking it from the perpetrator. Then unfortunately Iowa law doesn't have any provisions that would make a special exception. So once you terminate those parental rights, you terminate that other party's child support obligation as well. So how can a survivor get relief on under the Rape Survivor Child Custody Act? Just generally about the Rape Survivor Child Custody Act, right now this is a brand new provision. Although passed in 2016, it's not been utilized in a way that has made case law, as we call it. At this point, what you have is essentially the legislature doing an action and adding the language to the code, but we don't actually see the judicial branch weighing in and seeing a case like this and then making some determinations that flush things out and provide some clarity. So if you have a survivor that's going through this, I would, although they can self-petition to the court, I would highly recommend that they have the assistance of legal counsel, either through a private attorney or through Iowa Legal Aid, because it's such a new area and unknown. There's a lot of things that need to be fleshed out, and the mechanism for kind of petitioning the court for termination of parental rights isn't as clear-cut, obviously, as we would hope, where they could just go to the courthouse and fill out a form. They can self-petition, but it has to be a petition that's drafted with the particular grounds under the 600A code section stating that you're seeking relief under the Rape Survivor Child Custody Act. And with all the provisions, it would just be better for them to be able to have the guidance of an attorney until things are kind of fleshed out or more clear. So now actually we've concluded our portion talking about the Rape Survivor Child Custody Act, and closely related as a option and safety planning tool for sexual assault survivors is the sexual assault protective order found in Iowa Code Section 236A. And so now we're going to kind of transition to kind of talk about the sexual assault protective orders here in Iowa. So what is 236A protective order? It is a civil protective order added to Iowa Code effective July 1, 2017. They are modeled after the 236 protective orders, and the 236 are the domestic violence protective orders. The difference between the 236 and the 236A protective orders are the 236A protective orders do not require a familial or intimate partner relationship or other domestic relationship between the plaintiff and defendant. And talking with advocates throughout the state, many of you have seen circumstances prior to 2017 or July 1, 2017, where you would have a sexual assault survivor go and seek a protective order. All they had available to them was a 236 protective order. Well, there was always a requirement that either have a domestic relationship, have a child in common, have lived together, and if that requirement wasn't met, if it was more of acquaintance rape or circumstances where it was not a domestic relationship, they weren't able to seek assistance and protection from the court. That, fortunately, is now done away with because they have the option of the 236 protective order. So how is it different than a 236 order? Again, can't reiterate enough. The biggest component is that the protective orders may be filed against dating partners, neighbors, co-workers, family members, acquaintances, classmates, or any other perpetrator of sexual abuse. It doesn't require that domestic relationship or cohabitation component any longer, like the 236 orders. So why would somebody want a 236A order? Someone would seek an order because they've already experienced sexual abuse, and these are the important components that you want to convey to the court. They fear further sexual abuse, physical or sexual abuse may occur. They have been harassed, threatened, or intimidated by the defendant or another person on the defendant's behalf. And as a note here, it can include, the 236A orders can actually include some protections for minor children who may have been harassed or threatened or intimidated by the defendant or another person on their behalf. If you have a survivor that's seeking an order and you take them to the courthouse to fill out the order, you will frequently or going through, it's not frequently, but to go through the application and petition process, you'll see that there's an option, is someone else, there are the minor children, people in the household that need to be protected by this order. And you can select that as a possibility for the order to cover them as well. So what do 236A orders do? The 236A orders order no further abuse by the plaintiff, against the plaintiff by the defendant. They order that the defendant must stay away from the plaintiff's home, residence, school, or employment. And this can include minor children of the plaintiff. So if there's some parties in the home that need to be protected as well, minor parties at home, then you can indicate that on when you petition the court for the 236A order. And then third, order no personal contact or third-party contact between the plaintiff and the defendant. So while we're discussing these 236A orders, Just generally for advocates to know, there are 3 different types of petitions that are available at your local courthouse. You can actually go to the clerk of court's office, ask them for the 236A order. Don't accept the 236 order, or please don't accept the answer that they don't have the 236A orders. They have access to it. They can find it on what is called Judicial SharePoint. And commonly, if you go to a clerk's office and they are unfamiliar with the 236A order because they're kind of new, you can say, oh, well, I've been told it can be found on Judicial SharePoint. And then commonly they'll go, oh, okay, and they'll look it up on the database, and they can get access to the forms. And you want the 236A forms particularly. There are, like I said, there are 3 different types of petitions available. One that is for an adult petitioner, so an adult seeking a protective order. One is that to be filed on the behalf of a minor. So if the party is under 18 and a minor, you can have an adult basically go in and petition for them, and that's the petitioner application that they would use. And then there's a third one that is used for wards. So if you have a party that you are guardian for, your survivor is incapacitated in some way and has a guardian, that would be the form that they would utilize. So with the process of the 236A orders, essentially they'll fill out the petition, they'll present it to the clerk of court. The clerk of court, and this can vary throughout the state, but more commonly what we're hearing is the clerk of court will take it back to the judge, and the judge will take a look. And again, going back to those burden of proof standards, the standard in this case, or these cases, is that lower standard of preponderance of the evidence, so the 50% and a feather. More likely than not that the abuse occurred the way the plaintiff described. And so they'll want to fill out their petition, state what evidence they do have that this occurred, and then the clerk of court will take it back to the judge, and the judge will determine whether or not they can be granted basically a temporary order until a hearing is set for the more permanent order. Sometimes I have heard of circumstances in which a judge has some additional questions. Maybe they feel like what is placed on the petition isn't sufficient enough for them to meet that preponderance of the evidence standard, and so they may have the petitioner or survivor basically be asked some additional questions so that he or she can make the determination of whether or not you met the civil standard for that temporary protective order. Again, the civil standard or burden of proof is preponderance of the evidence. Again, just another way in which the 236A and 236 domestic violence orders are similar. They utilize the same standard of evidence. So if the defendant does, or if the plaintiff and defendant have minor children. So we talked a little bit about if the plaintiff is going, and maybe, let's just give a scenario, the plaintiff has a minor child, a 10-year-old daughter, but that 10-year-old daughter isn't shared by the defendant or the party that has caused the harm. It's very likely that the plaintiff can get a protective order that says, please protect me and please protect my 10-year-old minor daughter. Now, if the plaintiff and defendant have minor children in common, so instead of it being the plaintiff's daughter, let's say the plaintiff has a 10-year-old daughter, but the parties have a 5-year-old son together. The court is very reluctant to try to establish visitation rules or custody, and certainly child support as well, on the basis of these protective orders. So just be prepared if there's divorce case ongoing or child support case or in modification or something of that sort that relates to custody or support or visitation that's already open. The judge is going to say, I'm not going to hear that here. You need to address those with your pending family law case. So some additional items to consider. In the case that the plaintiff and defendant cohabitate or live together, and they can establish who vacates the home and what property is awarded with these protective orders. So essentially what that means is if both parties are on the lease and the plaintiff seeks a protective order, the protective orders will essentially provide so that she can stay in that apartment on that lease. Or if the one party owns the home, so let's say the defendant or perpetrator in this case owns the home, and a protective order is issued, he can't kick her out and have her evicted from the home, but at the same time, it doesn't make that property hers. It just essentially means that for the time being, she can stay there. It doesn't change title or give or award deed or title of a property or a home to either party permanently. Again, talking about differences between the 236A and the 236. The 236A important component to remember is that the protection is attached to the person, not necessarily the place. So we know if you're seeking a protective order and maybe it's against a coworker or a classmate or someone that you have interactions with, you shouldn't, your survivor shouldn't automatically assume, and you should guide them to know that it doesn't mean that the other party, when the protective order is granted, is kicked out of school or removed from school or terminated from their employment. What it does mean is essentially you do have that protective order. It's attached to you, and then that's when you need to engage in safety planning and discussions with your campus or your school about what your course schedule looks like, when you need to be on campus, where do you park, with employers, maybe making changes to work schedules so that both parties don't have the same shift or aren't on the premises at the same time. So more making safety planning accommodations, but certainly letting those entities, employers, campuses, schools, know that you have this 236A protective order that's been issued by a district court, and that they need to make some accommodations to assist in keeping you safe. So 236A orders, they're police enforced. Law enforcement has a duty to use every reasonable means to enforce the order. If probable cause exists that the order has been violated, law enforcement will take the defendant into custody. What you traditionally see is if you have a potential violation situation, please encourage your survivors to contact law enforcement or call 911. Let them know that they have a protective order out against this individual and that they are in close proximity to them or somewhere that they should not be. Law enforcement will come out and do an investigation. They may choose to take the defendant into custody. They also may choose to basically question the defendant, detain them briefly, and let them go, but then pass that report on to the court for the court to make a determination whether or not there was a violation. I've seen this to be much more common, that they'll basically, law enforcement will do an investigation and provide evidence of, okay, yes, we came to this place at 8:32 p.m. and this party was here, and there's a protective order against them. You know, do we have probable cause enough to arrest this party and actually put them into jail? And then that determination can be made by a judge. So what can happen if a defendant is found in contempt of an order? Defendant can be put in county jail for a minimum of 7 days. A violation of a 236A protective order is a public offense and punishable as a simple misdemeanor. So how does the survivor get a 236A? Comprehensive advocacy programs throughout the state. We've done quite a bit of training with advocates across the state, but again, we were talking about the Rape Survivor Child Custody Act today, reiterating that the 236 is also an option. 236A is also a great option for our sexual assault survivors, because the comprehensive programs, it's wonderful for survivors to be able to go into their local program and know that they can have an advocate accompany them to the courthouse and help them fill out this petition and go through the process with them. Again, you can also seek assistance with Iowa Legal Aid or a private attorney. And with the 236A circumstances, a survivor can actually go to the courthouse and self-petition or fill out the forms themselves and ask the county clerk for assistance in accessing the paperwork. Advocates are able to assist victims, like we said, with member programs throughout the state. Advocates are a wonderful resource for survivors. The advocates, it's more seasoned advocates, have done quite a few of either the domestic violence orders or now have started to do quite a few of the 236A sexual assault protective orders. And they can provide trauma-informed assistance with filling out the paperwork, letting the survivor know, hey, here's what you can expect. Or if they're more familiar with judges in a particular county, kind of talking to the survivor about things that they have seen in the past or know that the judge has preference for when they're filling out the paperwork, to make sure there's enough detail. They can provide advocacy and support throughout the hearing process for both the temporary and permanent orders, so doing court accompaniment, and just follow-up services and support such as counseling, safety planning, and ongoing advocacy. Again, helping register for IPON and Iowa VINE if it's applicable. And when the permanent order is due to expire, so permanent orders are issued for a term of 1 year. When it comes up towards the end of that 1 year, advocates can help with filing for renewal if the survivor still feels unsafe. So this concludes the webinar covering the Rape Survivor Child Custody Act and our discussion about sexual assault protective orders here in Iowa. Again, my name is Sherelle Thurston-Shell. I'm staff attorney here at Iowa CASA. If you have any questions, concerns, thoughts, or need technical assistance or connection with providing resources to survivors, please feel free to email me, give me a call. I appreciate you taking the time to attend this webinar, and thank you.